All right, so we're going to delve a little bit deeper into trademarks. All right, um, and I want to talk about two types of trademark protection. All right, the first and oldest is common law trademark protection, which really originates from equity and fairness. Um, and it did even exist in England. So it kind of came over on the Mayflower. And the idea was that if you had a trademark, color scheme, trade name, and you used it to market your goods or services, you had a common law trademark right. And you could sue for infringement if other companies tried to use confusing marks. Okay, so um, that's common law trade. The shortcomings of common law trademark protection is you only had protection in the markets in which you had competed. So in other words, if I open a hot dog stand in Cincinnati that has distinctive logos, and a family is on vacation from Seattle, and they see the logo, the color scheme, they like it, and they open up a similarly trademarked hot dog stand in Seattle, I would have no protection under common law because I hadn't previously competed in that market. So that's how common law trademark works. So obviously that was somewhat problematic. So federal trademark laws, as we know them, really started to take shape with the Lanham Act in 1946. So you could register your trademark, and that gives you protection not only in the entirety of the United States, but also internationally due to treaty. All right. So that's why even if you have used your trademark, in fact, you have to have used a trademark to register it. So you can't register trademarks that aren't in use. Right? You have to create it, use it in commerce, and then you're eligible for federal trademark protection. All right. But that's how the interplay between common law trademark protection and federal protection under the Lanham Act work. So what can be trademarked? Obviously logos. Perhaps you've seen this one. That's and we see this little R. That means it's a registered trademark with the USPTO. Slogans. All right. Now here, and I'm sure none of you have ever seen this logo before, but this is Budweiser. They make beer, malt beverages, if you will. Um, and so we've actually got a couple of trademarks here. Because the Budweiser bow tie is trademarked. All right. That's a trademarked logo. This Budweiser font and the name itself are trademarked. All right, we see this registered trademark. But if we look, we also see another registered trademark logo here. And it's a trademark slogan. King of beers, and there can only be one king, of course. And according to the USPTO, it is, in fact, Budweiser. So if I develop my own beer, I could not market it as the king of beers. I would get if I were to do so, I would get a strongly worded cease and desist letter from Budweiser's attorneys. All right. Uh, Nike swoosh, obviously that's the logo, and the slogan, just do it. All right. Notice Nike does not use the registered trademark logo anymore. It's not actually required. It's just suggested. Um, and another, um, Taste the Rainbow, trademark slogan. All right. You can also trademark sounds. All right. So below this lecture, I'm going to link to the USPTO Soundmark website, and they have several samples. And I encourage you to access that site and click through. Some of them you'll recognize. Homer Simpson's "Dope" is there, and if you're at the beginning of movies, the MGM, the Lion Roar, is there, and several other interesting sounds. So I'm going to link that below. But no, you can also trademark a sound, right? As many of you are listening to this, you're listening to it on your Apple PC, or your Apple laptop. Well, when you cut that on, it has a gong sound. Well, guess what? That's a trademark. If I were to create my own line of laptops, they can't start up like that. All right, they can't make that sound, I should say, upon startup. All right. So there are two main torts that we'll need to be aware of as it relates to trademarks. The first is infringement. All right. So the dispositive or the key trait of an infringement claim is a mark that is confusing. I go to buy one thing and I buy the product of another company because the trademarks are confusing to the consumer. All right. That is the essential claim in a trademark infringement case. All right. Keep in mind, it doesn't require intent. So accidental infringement is still infringement, and you can be sued and held responsible for accidental infringement. The idea being that when you bring product to market, you have a responsibility to look for similar logos. All right. So what does an infringement case look like? All right. Well, Aquafresh, for over 3 decades, has marketed its toothpaste using this shape with 3 stripes. All right. A little bit of trivia here. That shape is actually called a nurdle. So feel free to use that next time you want to impress your friends at a party. As that never comes up in life, but you know it now. So the shape of toothpaste on your toothbrush is called a nurdle. All right. Colgate brought its triple action toothpaste to market, and it featured similar shape with 3 colors. All right. Aquafresh took exception and sued. Well, actually, they sent a cease and desist letter to Colgate. All right. They settled out of court, so we don't have the terms of the settlement, but what we do have is the redesigned Colgate box. All right. So they took that shape and the nurdle off of the Colgate tube, right? And you can see how this might be confusing, all right? Because if you went to the store to get Aquafresh and you're used to looking for that shape, you might have picked up the same box, presumably with the same color schemes. They were both red boxes. So Colgate did change that, all right? Here's another one. This is Airbase Industries versus Marvel Rights LLC, which is a wholly owned subsidiary of Disney. All right. So what we're looking at is an air compressor. All right. It's a product of Airbase Industries. All right. And if you're not familiar with what these do, this cylinder, you can, there's a motor here that compresses air under high pressure in this cylinder, and you can connect any air tool. You can use it to inflate car tires, you can use it to drive a nail gun, staple gun, um, air wrenches, any air tool, you can hook up to it. All right. It is worth noting, Airbase Industries is not in any way affiliated with Disney. Right. They make air tools. What we see here is just a cutout from the Hulk, or one of the Hulk movies, in a block font. So Disney took exception with this air compressor. They didn't like the block font, the color scheme. Also, the most recent Hulk movie, the slogan that Disney brought it to market with was "Unleash the Fury." All right, and so collectively, Disney. I mean, if you just from an objective standpoint, you might think that there's a tie-in here, like this is endorsed by the movie or Disney or some Marvel character, i.e., the Incredible Hulk, and it's not. There was no financial agreement between Disney and Airbase Industries, so it felt like free ridership. Disney is a company that is very aggressive when it comes to protecting its intellectual property. So they tend to sue first and ask questions later. All right. And that's what happened here. All right. Didn't go to court, but Airbase Industries did redesign their air compressor. They still called it the Hulk. Disney doesn't own the word the Hulk, right? They did change the color scheme, and they did away with the "Unleash the Power" tagline on the air compressor. But they painted it a different color. Functionally, it's the same. It just does not look like there's a tie-in with the Hulk movies. All right. Again, out of court settlement, so we don't know if there was a financial change or not. I will say this is similar to David and Goliath. Disney is a huge company. They own ESPN, ABC, and obviously Marvel Rights was a party to this lawsuit. And Airbase Industries was a relatively smaller company, so there may or may not have been, probably weren't. Disney was probably okay with the redesign, but that's my speculation. Anyway, those are a couple of examples of trademark dilution, trademark infringement. All right. So let's shift gears for a minute and talk about trademark dilution. All right. It's the second tort I want us to be familiar with as it relates to trademarks. All right. And it occurs when a similar trademark is used that causes an association. There doesn't have to be any confusion here. So with trademark infringement, think confusion, right? With trademark dilution, the test is an impairment or damage to the protected trademark. All right? So that's what we're looking for here. A few examples I've pulled. All right? So Ben & Jerry's, it's a company, good wholesome company we've talked about. They're a B Corp and a benefit corp. All right, they give back to the community. They stake a lot on their company's reputation. All right, I just have XXX here. The case at issue was Ben & Cherries, which was a studio producing ice cream themed adult entertainment or pornography. All right, so I'll spare you the logo. But Ben & Jerry's did sue. And they didn't have a case for trademark infringement because there's not any confusion. Because if you're wanting ice cream, there's not a good chance that you're going to come back with, pornography and vice versa. So there wasn't really confusion. So it's not infringement. But the idea was that the comparison, the Ben & Jerry's, the similarity, changed, potentially damaged the wholesome brand that Ben & Jerry's had created. All right. And Ben & Jerry's wins this case. All right. So they are in fact successful. All right. That's an example of a successful trademark dilution case. Up next, we'll talk about an unsuccessful trademark dilution case. All right, and I'll link to all of these below this lecture. This is Louis Vuitton versus Hot Diggity Dog that makes dog chew toys. So obviously we have the picture of a high-end handbag on one side and a picture of a dog chew toy, obviously inspired by the handbag, on the other image. All right. So Louis Vuitton did not find this interest. They didn't get the joke. All right. And they sued Hot Diggity Dog, which is the manufacturer of this dog chew toy, for trademark dilution. All right. They are unsuccessful. Louis Vuitton loses this case. The judge in the case finds that there isn't any, or there's very, very minimal risk of the dog chew toy impairing the brand of Louis Vuitton. All right. And obviously there's zero risk of confusion here, because if I wanted to give one of these as a gift to my wife, there's very little chance that I accidentally pick up this, right? Pick up the dog chew toy, right? So obviously it's not an infringement case. Is it trademark dilution? And the judge in this case said no, and the reason being, it actually tends to bolster the brand. It tends to increase the cachet or reputation of the brand. This type of imitation does, and it's a protected parody. So Louis Vuitton loses this case. All right.